Welcome. My name is Eric Morehead, and I'm Senior Compliance Counsel with Corpedia, an NYSE Euronext company. And I'm pleased to welcome you to our first of regular anti-corruption updates. And I'm also pleased to be joined with Leslie R. Caldwell, a partner with Morgan Lewis here in New York City. Her practice concentrates on internal investigations and white-collar representation of companies and individuals facing government scrutiny and other serious crises. She leads the National Morgan Lewis white-collar team and previously served in the U.S. Department of Justice, including as the head of the Enron Task Force from 2002 until 2004, where I originally met her down in Houston, Texas. She oversees all aspects of the complex investigation there in the Enron case, which resulted in the prosecution of more than 30 individuals. And prior to that, she spent some time in both the U.S. Attorney's Office in San Francisco and here in Brooklyn, New York. She's successfully tried many cases, and we're very pleased to have her here to talk about FCPA and anti-corruption.
Thank you, Eric.
This year, in 2013, and really for the last 4 months, there's been a lot of discussion about the guidance that was released by the SEC and the DOJ on the FCPA. A lot of practitioners that are our colleagues have sort of designated this as old wine in a new bottle. I'm curious as to what your opinion is of overall the guidance and what kind of key takeaways we can take from the guidance from SEC and DOJ.
I think that the colleagues who say it's old wine in a new bottle are basically right. It might not even be a new bottle. I think that the guidance is helpful in the sense that it does include some examples of what kind of calls prosecutors would make in particular fact patterns. I think it's also helpful in that it emphasizes the need to have a tailored compliance program as opposed to just a compliance program. Mm-hmm. And I think that's extremely important for companies to take away from the guidance, that everyone has to have a compliance program, and it really needs to be very specifically tailored to the particular company's needs, and it also has to be tailored geographically, so that the same company may have the same paper compliance program in, say, China and Brazil, but needs to implement it differently and needs to train differently, needs to take into account the local issues, mm-hmm. And make sure that they do that across the globe, mm-hmm. because there really are significant variations.
Beyond tailoring to locality, what are some other failures, if you will, that you've seen in anti-corruption programs in the organizations, common issues that come up when you are doing an investigation internally or representing a client?
I think that there's a natural tendency to implement a compliance program, conduct training on the compliance program, and then not follow up with continued reinforcement. I think that continued reinforcement is incredibly important. Mm-hmm. And a compliance program is a living thing. Mm-hmm. It has to evolve. It has to change with the times. It has to change with the economy of the country that it's in. And new people are hired all the time. And there really has to be almost a drumbeat from really corporate headquarters. Mm-hmm. And people in the field have to really believe that corporate headquarters has bought into this. This is extremely important. And regional managers have bought into it, and mm-hmm. down to the ground level, people have to believe that this is really what the real rules are, as opposed to this is what we're supposed to be doing, but here's how we really do it.
Mm-hmm. Well, one of the things that's first mentioned in Chapter 5 of the guidance is culture. And I think that kind of plays into that. And is it your experience when you're working with an organization, either, again, as an internal investigation or representing them when there's an issue that's come up, those companies with stronger culture tend to have, I wouldn't say less problems, but have handled their problems better?
Absolutely. I've seen some wide variations, even with very large companies. I've seen some very wide variations in the quality of not so much the written program, but the way it's implemented. Mm-hmm. There's one very large company, which I won't mention by name, where the CEO refused to sign a letter, to sign the sort of annual compliance is very important to this company letter, because he said, we don't hire unethical people. Mm-hmm. And that kind of mindset, I mean, that's a very utopian way of viewing your company, but mm-hmm. it's just not practical in today's world. I mean, people don't have to be unethical to violate the FCPA. They just have to do something that may be consistent with the local culture. So I think that that's incredibly important, and I think that it really does need to come from the very top of the company, and I think it needs to be reinforced from the top of the company. Mm-hmm. I think that the general counsel and the chief compliance officer and maybe even the CEO or other senior management need to get out there in the field fairly frequently and make sure that that things are being taken seriously. Another thing that I think companies sometimes fall short on is really making sure that they know who they're dealing with, who their third-party partners are, their resellers, their end-user customers, any intermediators, excuse me, that they're using. They really need to know who those people are and what they're doing, and make sure they're getting value for their money and understand where their money's being used for. And
I find sometimes also it's important for those of us in compliance or in the general counsel's office to understand why we're doing business with that particular third party in the first place.
Exactly.
Yeah.
Yes, if you find that you're in a situation where you're doing business, you're doing a transaction that has multiple layers of third parties, you've got to ask yourself, why do we need all these people? And you need to understand what each one of them is doing. You also need to be able to have the right to go to them and demand to know what they're doing and demand to see what they're doing. And some companies don't insist upon that because they're afraid that that'll box them out of the market and give them a competitive disadvantage. But you really need to know who you're working with.
Absolutely. Beyond the borders of the United States, we've seen some action around anti-corruption laws in obviously the UK Bribery Act starting back in 2010 and being enforced in 2011. When you look at UK Bribery Act and some of the other actions that governments are taking around the world, could 2013 be the year where we start to see more enforcement overseas? What's sort of your feeling on that?
I think it's hard to predict, and don't forget the FCPA itself wasn't very aggressively enforced for maybe the first 20 years of its existence. I think that it's going to depend on whether these countries devote resources to enforcement. It's one thing to have a law in the books and another thing to actually go out and enforce it. I don't think most of the countries that have passed laws have really devoted tremendous resources to actually bringing cases, and these cases can be very labor intensive. The gestation period for making the case can be quite long. By definition, you have to get documents from other countries, which can be challenging. So I think it remains to be seen whether these laws will create a whole bevy of new cases or whether they'll take a while to get started.
Yeah, that's one thing that I've heard others say too, is that don't forget that the FCPA has been around since 1977, and we really didn't come to the radar screen of most general counsel and compliance officers until, what, 10, 12 years ago.
Exactly.
So that's an important point. Talking again about what the department does, 2012 was also the year that we saw the Morgan Stanley declination that included a press release from the department where they lauded the compliance efforts of the organization. That was, I think, fairly unique. There's certainly been declinations before, and certainly we all know of declinations that happened because of compliance. Compliance was a factor in mitigation there, but this was sort of unique to kind of put the company front and center for their efforts around compliance. Do you think that's a trend? Do you think we're going to see more of that, where the government sort of has poster children, if you will?
I think it would be smart for the government to do that, because I think right now companies are not sure what benefit they get from self-reporting and cooperation. So I think it would be very smart for the government to announce things like the Morgan Stanley declination, so that companies will see that, yes, we can also get, or possibly get, that declination. Although I have to say, having looked at the Morgan Stanley facts that are at least in the public record, I don't see a very significant distinction between the Morgan Stanley conduct, compliance and remediation efforts, and that of many other companies.
And that's something that other people have said too, that when you look at what Morgan had done internally, although laudable and certainly lauded by the government, may not be that different from others. And one of the things, going back to our first question, that the guidance, I think a lot of people were hopeful the guidance would do, is sort of give us that roadmap, which I think most people think it really didn't give you the roadmap for a declination. I have an opinion about this. I think that it's unlikely that the department would ever do that. I'm curious, since you have plenty of experience on both sides of the fence, do you think the department ever might lay out a roadmap that's more specific?
I think it's really difficult for them to do that. I don't think they will. I don't think they can, because I think that if they say, if you do A, B, and C, you get a declination, there will be, the next level of fighting will be over what constitutes A, what constitutes B, and what constitutes C. You know, there's already some discussion within the department or with the department when you cooperate. What does fully cooperate? What does immediately, promptly, what do those words mean? So I don't think that they really can. I don't think they can give anyone kind of an advance, because really these FCPA cases are very fact specific. And it's difficult to anticipate all the potential fact patterns out there. I think they did try to do a little bit of that in giving the guidance about you can take somebody out to dinner, you can pay for their cabs, but you can't fly them and their family around the world on a 1 month paid vacation. So I think they tried to do that. They tried to signal, I think, look, we will exercise judgment and discretion. We're not going to bring a case just because there has been a violation of the statute. But I don't think they really are in a position to say even what the UK anti-bribery statute says about a compliance program being an affirmative defense, because there's really no one-size-fits-all, and it's very fact-specific. Yeah,
yeah, and I think that's what we're left with, and we do have some, I think, helpful guidance in there of what broadly constitutes an effective program, both there and in the sentencing guidelines. So that leaves us to kind of weather the storm and try to plot our course, I guess.
Yes, exactly. Feel our way.
Well, I can't thank you enough, Leslie, for joining us today.
Thank you. It's my pleasure.
And thank you as well. And we'll be back at you soon with another update. Thank you.